following program is classified G. It's suitable for all ages.
Tonight, we discuss the fundamental law that governs fraudulent documentation. Sri Lankan law has given a lot of attention to the aspects of authentication, which is witnessed in the authority of notaries and justices of peace. In this backdrop, we question whether the law has done enough to create a more conducive environment to identify falsification, especially in the business environment. Where are the loopholes? What are the key reforms required in the future to strengthen the identification of fraudulent documents? Welcome to Law, Land and Liberty, where we are keeping with the promise of bringing in a contemporary legal topic and breaking it down for our viewers. Today we are going to talk about a topic that affects almost everyone in our country, especially when you move into the business atmosphere. And that is with relevance to fraudulent documentation and how exactly we can address that, how exactly the law in our country is addressing that. And to discuss this matter, we have with us none other than President's Counsel Neville Abeyratne, someone who is an expert in this field. Thank you so much, sir, for joining us on today's program. We have a lot to discuss with you, a lot of important details to gather from you, from your experience in this field. 40 years of experience as a lawyer and President's Counsel. We will be discussing we'll be going into details shortly. What we generally do within this program is we give a breakdown to our viewers about what exactly we'll be covering, so that it's easier for our viewers to keep track with what we will be discussing. Firstly, we are going to talk a bit about documentations related to land matters, which is where we'll be dealing with a lot of the crux of the portion within this discussion. Secondly, the prevention of fraud ordinance. Thirdly, the role of a notary. And finally, reforms relevant to this section.
Hi, my name is Johnney and I'm a fourth year medical undergraduate. My question is about documents related to land matters. What are the potential fraudulent documentation identified in land matters and how are they addressed in Sri Lankan law?
All right, let's get into the discussion directly. President's Counsel Neville Abeyratne. Once again, thank you so much, sir, for joining us on this very important topic. So the first segment, as we were just explaining to our viewers, is going to particularly base on the documentations related to land matters. And there we have a huge array of things to discuss, pertaining from the authorities that are in charge to things subtle things such as deeds and wills. My first question to you, sir, was going to be, now what exactly is the primary differentiating factor between a will and a deed in relevance to that? Because those are two key documents that we deal with when it comes to this specific subject. As you approach that, sir, you can also give a basic introduction to how you approach this topic, why you believe this is important, and we can continue our discussion from that point.
Thank you, Dhananjay, for first inviting me for this valuable discussion. It's very relevant and very important as we think of the transaction that is effected today. And you know, the lawyers or the notary publics in this country are the responsible persons for the transfer of ownership of lands. No other persons could transfer a property. You see, most of the litigation in courts and dispute arises with regard to the ownership rights of the property or any encumbrances or rights affecting the property. And you see, especially in Colombo and suburbs and even in outstation now, the value of the properties are going really up. It's really value. And a person who purchases a property has to pay a large amount of money. Probably his saved money.
Entire savings would go.
Entire saving of the entire life, sometimes the provident funds or the last termination or gratuity payments, and all that hard-earned money will go into the purchase of the land. And therefore, it is very important that even the notaries, the general public must be aware of the dangers of purchasing a property and to make it sure that you correctly get the ownership of the property. Now, to that extent, we have a number of acts that is in force, the law law mainly with regard to the transfer of properties is the Notary's Ordinance and the Prevention of Fraud Ordinance and the Registration of Documents Ordinance. And there are the other laws which have direct dealings or direct effect with regard to the transfer of properties, which we will deal with it as we go on. Now, raising the question on with regard to the main difference between a last will and a deed. Now, properties that we have to basically a division with regard to property, if you call movable property and immovable property. Movable property means the property that it could be moved or whatever, you know, the other areas except the land. Lands are called, named and defined as immovable property. Now, these immovable properties, that is land, building, houses, those could be transferred by legal documentation called the deed. Now, it has to be transferred before a notary public. It should be legally executed and attested by a notary public in the presence of two witnesses, at least two witnesses, and in the presence of one another, all being present together. That is the most important thing. Now, the last will is also a legal document where it should be legally attested by a notary public who have license in that particular district, in the judicial district, to attest the document, and it must also be signed before two witnesses. All the executor and the witnesses, notary, all be present together at one time in the presence of one another. Now, both in a deed of transfer could be by way of a gift or by way of a transfer or purchasing of a property. Sale, when you buy a property, maybe by private sale or a public auction, you can execute the deed. By a deed of transfer, you become the owner. Even a gift, a person could gift or donate a property to a person. But normally what happens in today's context is that the parents always gift the property to their children. Now, both in last will and in deeds, you transfer the ownership of the property. You are moving, that you are effecting a transfer of a property. Now, if you write a law, now these days, I have seen that lots of people are trying to execute last wills. Maybe because of the economic situations or various problems, they are now, more of them, they are writing the last will. The main difference is that when you write and execute the deed, the ownership of the property is transferred at the time of execution of the deed. At the time of execution of the deed. But in the last will, it is not that. Now, a last will, once you write a last will, it comes to an effect once that person ends his life. If he ends his life, if he expires, or after the termination of his life, then the last will come into play. But most important thing is the last will, you will have to put before the court. You have to place it before the court and prove the last will in court. That is the important thing. So, simply because you have a last will, that doesn't mean that you are the owner of the property. Make sure within a specified time, as early as possible, you must go to the district court where the land is situated, or any of the land that is mentioned in the last will of the deceased testator situated, or at the place where the deceased died. The nearest district court, you must file a testamentary action and then prove the last will that it is the genuine act, that he was in good health and disposing mind, who had the thought of judgments and reflections, and that has to be proved in court in order to get the title to the property. So the main issue is, the difference is that by executing a deed of transfer or gift, it becomes operative. Ownership is transferred at the time you execute the deed.
Yeah.
But in the last will, you have to go to courts, prove the last will that it is not a fraudulent act, it is a genuine, thoughtful act of the deceased testator, and after the proof of that last will only, you become the owner of that property.
Right. Just to get a initial clarification, sir, even if the last will is not contested, that process should be followed. As in, a person, if they are within the hands of, they have the last will within their hands,
yes,
they still have to prove it within courts for legitimacy or the authentication of that property.
That's a very good question, because some of the view that the mere writing of the last will is sufficient.
Yeah.
Even if there is no contest,
Yeah.
you will have to file papers in the district court. Testamentary proceeding must go.
Okay.
It can be contested or uncontested.
Right.
If it is uncontested, it is very easy. There are about 10-12 steps to be taken in the district court. Within 8 to 9 or maximum of 1 year, you can finish the entire proceeding.
Right.
Because it must be published in the papers, and then objections time to be allowed. Some, if the property is under mortgage or even under, if there are some liabilities attached to the property, the banks or financial institution might come up to courts.
Right.
So those steps have to be taken.
Right. So I think based on that, a lot of questions that I have, it might even bleed into the next section. We'll take it step by step next on the Register of Lands. Now, that is an authority that people are generally aware of when it comes to an authentication of a deed or in terms of the registration aspect. What is the role the Register of Lands play in terms of the document's authentication, in terms of the document not being fraudulent?
Now, actually, number of forged deeds had gone in for registration, fraudulent deeds. The registrar cannot check or verify whether these documents are forged or otherwise. It is the primary duty of the notary to see that the deed of transfer or that transaction has properly taken place,
Yeah.
on documentation. Now today, other than the areas which are gazetted and title registration is in issue, we had the process of registration of documents.
Yes.
Now, simply because you have a deed, that doesn't mean that you can be the owner.
Okay.
Because the lawyer must do a proper search and see that the proper title is transferred. Merely because...
If you can explain that area, because one would say if you have the deed, then
yes,
the land is yours. But
merely because you have a deed and even registered in the land registry, you may not be the real owner.
right.
It is a process where title to the land, title means the real ownership.
Yeah.
We call it the owner of soil rights owner of the land. He must derive the title at least to 30 to 40 years, must get the title on proper deeds, divided and defined portion of land, on proper plans and proper deeds, and the title must come from the owner. You say first owner is A, then it comes to B, it comes to C, like that. Proper transfer or the gift of ownership must be there.
Okay.
And it must be properly registered in the land registry. And also that it is very important to see that the original deeds are kept and the original plans are kept for any lawyer to check the genuinity of the document and to see whether he is the real owner. Now, for instance, that once you have to go for a bank loan or transfer of properties, the lawyer with a background, with practice in the district court in civil litigation, he has to examine the title
Right.
and give a title report.
Okay.
So that is how, but the land registrar of lands, he only registered the document.
Okay.
He has no way, very limited way of checking it is not his function,
Yes.
actually, to see that the document is a fraudulent one.
Right.
If he goes through the document and see if he is a notary in that notary, and that he has attested the document, proper stamp duty has been paid, and all the other requirement in the registration of documents is followed, then he register the deed. But
Right.
that doesn't mean that you become the owner. That's completely a different area.
Right. If you can tell again, just to clarify there, I think that's something that people would like to hear from you, sir, about what are the other contesting factors that might come into play if the deed and if you are registered under the Register of Lands. What are the other issues that you need to look into? Is it just the title that you need to look into, whether there has been any contentions in the past, 5-6 decades, or what should you be careful of?
I'll tell you, but I think this is very important to address.
Yeah.
Some of the errors or common mistakes done by our notaries. Now, how a document become fraudulent? It could be a person other than the owner execute the document. It's called impersonation.
Right.
It's not the real owner. Real owner is A, but person B might pose as A and sign the deed. So it is the identity of the person is very valuable.
Yeah.
So the document becomes fraudulent because impersonation. The real owner will not sign, somebody else will sign, will execute the deed. And then also the land. You have to identify clearly the land.
Yeah.
Where is the land? And also that he must have the legal title, identify the land, and then effect the transfer. But I will go to the common mistakes done by the notaries and notaries.
Yeah.
It's say the lack of proper identification of parties involved. Vendor means the person who sells, or donor means the person who gives, the donor gifting the property.
Yeah.
Then in that particular deed, make sure that your identification documents are mentioned. I have seen some of the deeds where not even the identity card number is not there.
Okay.
Some notaries forget to do that, and the clients also doesn't insist that it should be mentioned. I think it's a duty of the notary to insert the identification document.
Yeah.
Now, as you know, everybody knows that the identification document today are the identity card, the passport or driving license.
Yeah.
So that must be mentioned with regard to the identity of the person. Then you must also be careful that the party who is executing the deed must have the mental and the physical state of mind and good health and disposing mind, that he must be in good health to execute the document.
Right.
Now, in a person in a hospital, is in a doubtful situation unless you bring the doctor as a witness.
Right.
And we have seen notaries and also the purchasers of land must be very careful to select the witnesses.
Yeah.
I have seen in some of the documents who are the witnesses. Your driver, somebody on the road, your clerk in the office, somebody. I say that somebody reliable, trustworthy, and known person must be brought in as witnesses.
Right.
Because I think the notaries also must think in this way, that this document can be questioned in court at any moment.
Right.
So the proof of document, when you come to the proof of document, at least one of the witnesses or the notaries must be called to give evidence.
Okay.
So if the witness is a untruthful person, it cannot be reliable, cannot be found, and then how the document could be proved?
Yeah. Yeah.
And if I go to the other examples of the common errors that they do, it is very important that in the attestation clause, how the consideration was passed. Consideration means the value that you pay for the land. Say you are buying the property for 10 million,
Okay.
or say 1 million, or whatever the amount. Mere just mentioning in the attestation is not sufficient.
Right.
You will have to say how that transaction took place. It is better, I always say it is better that the money transaction should be done by through banks.
Right.
Then you are safe.
There is a money trail there then. So, a very important initial discussion. We'll take this conversation forward, but first we'll take a very short break. You're watching Law, Line and Liberty. Stay with us.
Abeyratne. I'm a clinical science student. My question is on the Prevention of Fraud Ordinance. What are the salient features in the Prevention of Fraud Ordinance with information in our country?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Neville Abeyratne. Sir, within this segment, what we want to get into is the ordinance, the Prevention of Fraud Ordinance. But as you mentioned, we have been discussing that step by step. As an initial question, if you can give a briefing to our viewers on what the Prevention of Fraud Ordinance encompasses and what subject areas they deal with, and moving a step further, what a buyer, or in this case, when it comes to land, the factors that they should be aware of, what they should be careful of, if you can take this.
That's a very important question. I will briefly deal with the Prevention of Fraud Ordinance.
Yeah.
That the Prevention of Fraud Ordinance, the purpose of the enactment is to prevent frauds.
Yeah.
So everybody, the lawyers, notaries must follow the strict sense what is stated in the Prevention of Fraud Ordinance.
Yeah.
Now it relates to, as I said earlier, relates to immovable property, that is land. And then if you are transferring the land, if you are even having a contract, an agreement of purchase, sale purchase agreement, that is, you may not have money to purchase the property or then and there by having, you don't have the money, but you have a contract and say that I will pay you advance of 1 million and pay the balance later.
Yeah.
And that has to be in a notarially executed document. That's what the Prevention of Fraud Ordinance says. So any rights affecting land, transfers, donations, agreement of sale, any encumbrances that you effect to the land, all must be notarially executed in terms of the Notary's Ordinance. Notary's Ordinance, Section 31 Notary's Ordinance gives number of provisions where notaries must follow. And I say that the old notaries or the law students, you must carefully read the Notaries Act, go to the Section 31 where it says how the rules that you should follow, all rules should be strictly followed.
Right.
So now I have seen the general public sometimes when they want to purchase a property, they just go and have a document signed to say that I am going to sell the property, sign on the stamp and take 1 million or whatever the advance, and it only relies, having the document only on a mere paper.
Right.
It is not executed before a lawyer, not notarially executed, and if that is breached, the owner might get a another big price for the land, then he will change his view and give to somebody else.
Right.
Probably you cannot refund your money.
Right.
The money, the advance that you have paid. So in order to execute that, to enforce that contract or agreement, it must be notarially executed, otherwise the court will not entertain your application. So it's very vital that Prevention of Frauds Ordinance provisions are clearly followed when you are purchasing a land.
Right. Moving forward from that point onwards, what I want to ask a bit about authorities in charge of this as well now. If our next segment is going to be on the role of a notary, so misconduct by a notary is also something that we would want to discuss within that segment. But just to give an initial briefing, what are the authorities people can reach out to in relevance to fraudulent documentation? What should a person do if they have an issue with authentication? What is the sort of suggestion that you would make?
Now, if a person is deceived by a person, it is because of the wrong person has signed,
Yeah.
or the proper witnesses had not been signed, and therefore the wrong land wrong person has been identified by
Yeah.
the witnesses. And sometimes the notaries fall into difficulties.
Yeah.
Because our law says for a notary to execute a deed, he must personally know the executant, that is the owner of the property or the donor of the property. If he doesn't know, the witnesses must know the executant, and the witnesses must know the notary. The notary can sign if the witnesses are known or the executant is known. So that is a very important factor that has to be considered.
Okay.
Then the notaries also must be careful to, I said earlier, that the value of the property, the valuation of the property is also very important. Now, in today's context, you will have to get the property valued by the valuation department. You have to go to the AGS office, or the valuation officers are there. You have to get the property valued to the market value of the property. So it is, before writing a deed, it is not mandatory according to the law, but it is always better that you get the valuation done by the valuation department, by the valuation authorities of the province, and then write the deed to the market value. Don't try to undervalue the property. Undervaluation might lead to various other problems. So property must be on the market value, properly assessed, and then the value must be reflected on the documentation. And as I said earlier, it is better that to avoid any kind of other transaction falling in, better to pay the money through banks and established bank and financial institutions.
So I think the reason why we spend a lot of time with regards to the lands and deeds in relevance to this is because that is the most important commodity in relevance to fraudulent documentation. Before we go into a break, so what are the other aspects now? One thing that comes to mind is the affidavits that are relevant to, when it's being brought to courts, that requires some form of authentication. What are other documents that are in place as a step further from lands, from issues related to land, that requires maybe some authentication from a notary or some form of authentication in front of courts? What are the other documents that are in place?
You will have to get the, if you are writing a deed or a legal document on a power of attorney. And this is also very important because some of the owners are now abroad. So their properties can be disposed of. Properties could be gifted, but there must be a proper power of attorney. You have to act on a power of attorney. That power of attorney must be properly executed. And if a person is abroad, it is better that it should be executed before Sri Lankan Embassy or High Commission office, because these officers could be easily brought to court if they want to prove the document. And then you will have to take an affidavit from the person who is executing the deed on behalf of the principal. Because the owner is abroad and the person is called the holder of power of attorney. The principal is abroad, holder of power of attorney in Sri Lanka. So you must take an affidavit that the power of attorney is genuine and it is enforced. Remember that the power of attorney could be revoked at any time. Following the proper procedure, it can be revoked. So it is important that you take a proper affidavit before you execute the deed. And also that today it's very easy, on a touch of a button you can discuss or you can converse with the principal who is abroad. You can see them on WhatsApp or whatever the material that you have. Touch of with the phone you can do all that. So the notice is better that you have though the power of attorney holder is here, better to discuss with the principal who is abroad before you attend to the transaction. And I forgot to answer that question. You raised a very important question as to what happened if you are cheated, where to make a complaint, how to take action. Then you have to first make the complaint. First make the complaint to the police. If the property, I think now according to the present valuation, you will have to make if it is a lower value, to the local police. If it is over 5 million, I think you have to make to the fraud bureau. If it is over 10 million, you have to make to the CID. So the police will initially take the initiation and do investigation and trying to find out the method or what manner the offence had been committed, and culprits to be brought to court, arrested and produced before court. And also that the documents, the forged document will be sent for the examiner of question document, government examiner of question document, for verifying the signature. Here I must say this, answering to your question, that we have seen that some of the persons who do fraudulent act, their signatures are, very simple signature. 1 or 2 letters, some marks here and there.
Yeah, yeah.
So it is better that you ask that person if you have with sometimes they sign their signature with 1 or 2 initials,
Yeah.
some marks.
Yeah.
So those we have to be very careful. Then if that is so,
They can be replicated easily.
And what you should say is, ask him to write the full name then.
Right.
Have the full name, let him ask him to write the full name and then sign it.
Yeah.
And because if that is done, then the examiner question document can examine it. Now we find once the police sends for examination of this document, EQD comes and say this is highly not proper and this is not adequate for them to compare the signatures and make a good opinion.
Right.
Because the signatures are too short.
True.
Then otherwise, then for the cancellation of deeds, other than the police complaint where he can be brought into the criminal court, you have to file a case plain before the district court asking to cancel and revoke that particular deed which have been fraudulently executed.
Right.
So you have to go before a lawyer and then properly present your case before the district court, alleging all the circumstances and say it is a fraudulent transaction and need to be set aside.
Right. I think that also gives a lot of clarity, sir. I thank you for that. We'll take a very short break. You're watching Law, Land and Liberty. Stay with us.
And I'm an engineering student. My question is about notarial law. What is the role played by a notary within Sri Lanka, and what are the laws that govern it?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Neville Abeyratne. Sir, 2 very informative segments that we just passed, and here we want to really take up the discussion of a role of a notary, and I think between the first 2 segments we discussed other elements of it. This brings me back to one of our initial questions on what a buyer should be aware of, what are the key factors that they should be looking into, because that is partially the notary's job as well when looking at whether all required elements are there within a deed or within any document that we will be discussing. How do you approach that specific question, so when you take the role of a notary, because it is a big responsibility, as you mentioned, they can be brought to courts and questioned with regards to that. I want to ask you towards the latter part of this discussion also about what happens if a notary passes away, and then in that instance who is going to be held accountable. But firstly, we start with the general role of a notary and what a buyer should be aware of when
purchasing a property. It's a very valuable question, an important question. I think the first thing is that you must select a experienced notary, a lawyer notary or notary public, who should be competent enough to properly check the documents. I should say what to check. First you must see that the original deeds are available. Right. No certified copies or no other copies. Original deeds must be available. Ask for the originals. Land registry search has to be done. At least between 30 to 50 years, land registry extract has to be checked properly. And sometimes I say even the duplicate has to be checked. Then you will have to get the plan. There should be a plan, survey plan. It should be an approved survey plan. If the land is subdivided, there should be a subdivision approval from the local authority concerned. Okay. That the subdivision must be approved under the UDA regulation. Now the UDA, Urban Development Act is in force in most of the areas. I think entire Sri Lanka except few areas. So it is under the law that subdivision plan has also to be approved. Okay. There is a planning committee consisting of UDA officers, technical officers in all local authorities, and subdivision plan must be approved. Then you will have to look for, if the plan is older than 10 years, the old plan, have a new plan within a period of 10 years. Okay. See that the boundaries can be easily identified. And then boundary stones or boundary marks are there clearly. And I also say that there were certain instances where people have not inspected the land that they are going to buy.
Okay.
The land have been washed off to the river or to the sea.
Right.
Only the mere documentation.
Okay.
And then, of course, if you are going to buy a house, see that it has been built according to the plan approved by the local authority.
Okay.
Otherwise, after you purchase, your building can be demolished, your house can be demolished. Ask for the approved plan, that is also important. And then the other issue is that ask for street lines which is near a roadway in most of the land. All the land must have an access road. So check whether there is proper access to the land,
Okay.
the clear access, the width of the roadway, otherwise you will have problem with the banks.
Yeah.
And then of course I said earlier that those plans has to be approved. And then street lines, non-vesting certificate. There are certain properties in Colombo, very high value.
Yeah.
They have not paid the municipal council taxes.
Right.
Municipal council annual taxes had not been paid, assessment has not been paid. It had got collected, aggregated, and interest factor also added. So the local authority can acquire that property for non-payment of taxes,
Right.
that assessment rates. So you have to get the certificate from the municipal council concerned and the ownership certificate from the municipal council, and those are the main documents. And check, have a title traced back to the 30 to 40, 50 years, and check the encumbrances list whether the property have been mortgaged, leased out. And
Right.
I say that most of the problems has occurred at the time of purchase of a property or a house. See that you get vacant possession.
Okay.
Don't buy a property over the head of the person who is living there.
Right.
So
If
see
you
that
can
you get
explain that a
vacant
bit,
possession.
Vacant possession.
I said if you are buying a land,
Yeah.
see that possession of the land is also taken
Right.
simultaneously at the time that the title is taken from the owner.
Okay.
The property, there are certain properties, you may have the title, but you may not have the possession.
Right.
That now suppose you buy a land with a house and there are tenants in the house.
Right.
So don't buy with the tenants. It's called over the head of the tenant.
Yeah.
Let them vacate before you purchase that property. Otherwise you have a different action. You will have to file papers and then go to court to see that they can be ejected. And also be careful under the Rent Act. There's some places in Colombo still the Rent Act applies. There are a lot of amendment which has now come into play and it is in force, and the rent has been, their rights of the tenants have been restricted to a certain extent, to a large extent, but still there are tenants.
Yeah.
Under the protection of the Rent Act, they cannot be ejected even if you purchase the property.
Okay.
So make sure that you get peaceful vacant possession when you purchase a property.
Right. I think that really clarifies a lot of doubts that people would have in engaging in transfer of lands. If we can, I think we touched on this as we went with the discussion, sir, but if you could give in a nutshell about, now there was a requirement for notary to take place because the registrar of lands cannot look at authentication or look into all of those elements, so the notary has a huge role to play, a huge responsibility to take. How would you describe that responsibility? What are the key features there? What in order to be a competent notary or in order to execute your duty properly, what are things that people maybe overlook that we should really be aware of?
I should say the notaries, I have always said that in various seminars also, that the notary must keep an instruction book. He must get the owner or the person disposing the property give written instructions. Because sometimes we say that he comes to say, the owner will come to court or to other authorities go and complain saying that I never sold this property. I wanted to mortgage this property, but you wrote a deed of transfer. So the duty of a notary is to reflect the genuine, correct transaction on the document. So some people today, when they want to take money, they go to a notary, they want to mortgage the property and get the money. So where the notary goes, and it is not because the notary, because the person who gives money wants the property transferred to his name. So get a deed of transfer. get a deed of transfer. But it is not the real transaction that took place between the parties.
Yeah.
So it's the duty of the notary to reflect the correct transaction.
Yeah.
That's important. Then I said get the instruction in writing.
Yeah.
That is very important. Then encourage clients to do the monetary transaction through banks are very important. Then the request, I always say request the executant and visitor to sign, write the identity card number and the date of signature. This is also very important. When you sign, you just get the signature. No, I seem to write the identity card number and date it, because I said earlier, executant, witness and notary must be present together at the same time, one before each other.
Yeah.
So the fact that fact is proved when you date it, that you on the same date that you sign it.
Yeah.
So that's important. And obtain photocopies of the identity cards and the parties and keep them preserved with your protocol. That is important. Then I said it is important, if it's a big transaction, that you take some photograph at the time of signing.
True.
Why
There's
not?
There's some proof of that.
That's a proof of that.
Yeah.
Then I said that the executants, if the signature is short, illegibly written, then requested to write the name that appears.
Okay.
Then I also said it is advisable, I said to carefully select the witnesses. Don't allow the family members or drivers sign as witnesses. Proof of documents is very important.
Yeah.
So therefore, I think the notaries has a big responsibility to execute the deed of transfer of immovable properties.
Right. I think that really puts into perspective what exactly the role of a notary is. We'll take a very short break and we'll join you on our last segment where we talk a bit about the reforms that are required within this field. You all are watching Law and Liberty. Stay with us.
And I'm a clinical science student. My question is about reforms. In the field of laws related to fraudulent documentation, what are the areas of reform that need to be looked at moving to the future?
Welcome back to Law, Land and Liberty. We are in conversation with President's Counsel Neville Abeyratne. So I think the substantive portion of this discussion has been covered, and there was a lot of important details that you really mentioned. But something that I really want to get from you, because you have been within this field for a very long time as an experienced lawyer, what are the areas, the loopholes that you have seen that you think that we need to look at, vacuums when it comes to addressing issues of fraudulent documentation? Maybe not in the law right now, but maybe in the future, things that we should look at, maybe to streamline the process, make the process more efficient. Because I don't have to tell you, but most lawyers that come here and mention the issues when it comes to land, they take a long period of time. And partially some amount would be dealing with the authentication of documents. What are the suggestions, or where are the key areas of reform that are required?
Thank you. That's a very important question. I think the Minister of Justice appointed a special committee of senior lawyers and to suggest various amendments to the existing law, and that have been done.
Yeah.
And I think the draft is ready, and it has gone to the department, and now before the legal draftment, I think it will be presented to the Parliament. And the most important suggestion that was made there was that you have to take a photograph of the owner of the property that should be attached to the deed. It is not there now, so the impersonation could be avoided.
Right.
Like the driving license or something, you have the owner's photograph attached to the deed.
Okay.
So that's a very vital suggestion that have been made. I think that will come to law. And then the other issue is that according to the law today, though people go for registration of document, register the deed, actually registration gives you only priority of registration.
Okay.
Simply because your document is registered, that doesn't give this gives the legal validity, but the priority is looked for. That is, a person could sell the property to 2 or 3 persons, even but it had to be by fraudulent transaction. But whoever goes first and gets the deed registered,
right,
gets the priority.
Okay.
That the registration of document is not a mandatory law.
Okay.
So we are going to make the provision that the deed must be registered in the land registry.
Okay.
So it must be registered in the land registry. So that is a very important suggestion. So those are the most two important suggestions.
Right.
And also that taking the photograph and then registration of deeds, and the power of attorneys also to be registered,
Yeah.
and the contents of the power of attorneys has to be looked for.
Yeah.
And I think mainly those are the new issues, new amendments that have been brought in.
Right. As the final question for this segment, I think a lot of important things that we have covered over the course of this entire discussion. So, what I want to clarify is, as we move forward, I think I move back to the issue of efficiency and things of that sort, because what we are looking for as a country is to have a conducive environment for enterprise, for business to occur, and it's vital that these elements are really ironed out, and things like fraudulent documentation doesn't occur, and we are strict, our laws are strict on that regards, especially when it comes to transactions and when it comes to enterprise. Where are the other key aspects? Do you think there are other legislation maybe away from the discussion that we have been having that we need to really focus on, be it maybe things like taxation, or maybe other aspects, of power of attorney being given, of ownership by foreigners within this country, things like that? Where are the aspects that we should be dealing with, where we should look into in comparison to other countries that have gone far ahead when it comes to transactions, when it comes to issues of land law?
Yes, now as the law today that the foreigners cannot own land in Sri Lanka.
Yeah.
That's a good salutary provision, but also now in condominium properties,
Yeah.
where you have the condominium price big buildings and residential and other commercial buildings, where even residential houses in condominium property, earlier it was should be the 5th floor and above a foreigner could purchase. Now it has been amended that even from the ground floor a foreigner could purchase a property.
Yeah.
And that is good. And also that it must be reflected and clearly shown that at the time of transfer of the property, the foreigner must transfer the foreign funds. The foreign funds could be transferred at the time of the transaction, and he must be able to prove that money came into Sri Lanka.
Okay.
I think that's a very good salutary provision, and that is in force today.
Yeah.
And restriction of foreigners having land to a certain extent it's good, and the Parliament has decided in their wisdom.
Yeah.
And also now allowing the condominium property to be purchased from the ground level is also salutary provisions.
Right.
And thereby they can increase the taxes, and the government can get much needed foreign exchange today.
Right. I think those are key aspects that we need to look into as we move forward. So unfortunately we will have to end our discussion there. There's a lot of other things that we'll discuss. Hopefully we'll meet you again with our program in the future. President's Counsel Neville Abeyratne, thank you so much, sir, for joining us.
Thank you for inviting me, and I was pleased to have a discussion with you on this very important subject.
Right.
Thank you very much.
Thank you so much,
Thank
sir.
you.
All right. The protective elements of the law not only extends to the conventional crimes, but rather to the false representations, especially in relevance to official documentation. It is an aspect that all citizens should be well aware of. Author Dorothy L. Sayers once said, "To make a deliberate falsification for personal gain is the last, worst depth to which either scholar or artist can descend in work or life." That is all from us here at Law, Land and Liberty. If you had missed today's program, you can re-watch the entire episode on our YouTube channel, youtube.com/Abeyratne English. I'm Daniduthan Vasa. Have a great night.